I'm going to try and get through the entirety of this document without being disturbed. There's no guarantees. First off, it's important to understand who you are. There's so many things in this life that cause a man to ascend to the mind, change his trajectory, change the way he views things. And I think this is part of becoming a man and evolving. I want to say, first off and foremost, I'm no better than anybody else. I'm not above the law. I don't operate outside the law, contrary to many people's belief. So we'll get started. I mean, it's my extensive studies, not only in the Bible, but also in man's law, that have changed the way that I look at things and the way that I perceive things. Ultimately, law is simple. Knowing the difference between wrong and right. I mean, it's so basic. It seems preposterous that I would even have to tell people what the law is. I mean, it's that simple. It really is. And unfortunately, man has a way of destroying everything they touch. And yeah, you guessed it. They attempted to destroy the law by touching it, by creating their own law, by trying to play God. And to a degree, they've been successful with hundreds of millions, if not billions of people, to a degree. But the law is perfect in every way, guys. The system is perfect. It's taken me a long time to come to this conclusion. I went through resentment, discontent, mental anguish. A number of different emotions took over me as I was studying this stuff. I felt betrayed, lied to, not only by my family, by my friends, by everybody who just continued to regurgitate the bullshit that they were hearing on TV. And as I started to read books, the people that I once had great admiration for because I believe they were just highly intelligent, I found were just simply watching the news and regurgitating the shit they heard. They weren't doing any studies on their own. And as I started doing my own studies, I started to discover that these people were completely and entirely brainwashed and full of crap. And the sad thing is, it was an entire community. And it's not just this community, it's many other communities. They're all stuck in the same fucking washing machine, doing the cycle thing. And very, very few ever get spit out of that cycle and start to comprehend what's really going on. So, today, I'm going to get through this. It's 22 pages, Lord willing, and provided. I want to get through this memorandum. It's a memorandum of law on the name, right? Many people are involved in diligent research concerning the use of the all capital letters name, proper name, ergo John Paul Jones, which is in all capital letters, as a substitute for John Paul Jones, which is proper case in nature. In all court documents, driver's license, bank accounts, birth certificates, etc., is the use of the all capital letters to designate a name some special English grammar rule or style? Is it a contemporary American style of English? Is the use of this form of capitalization recognized by the educational authorities? Is this an official judicial or U.S. government rule and or style of grammar? Why do attorneys, clerks, court clerks, prosecutors, judges, insurance companies, banks, credit card companies, utility companies, etc. always use all capital letters when writing a proper name? What the English grammar experts say. One of the foremost authorities on the American English grammar style composition and rules is the Chicago Styles Manual. The latest, the 14th edition, published by the University of Chicago Press, is internationally known and respected as a major contribution to maintaining and improving the standards of written or printed text. Since we can find no reference in their manual concerning the use of all capital letters with a proper name or any other usage, we wrote the editor and asked this question: is it acceptable, or is there any rule of English grammar to allow a proper name to be written in all capital letters? For example, if my name was John Paul Jones, written proper case, can it be written as John Paul Jones, capitis maximus? Is there any rule covering this? The editorial staff of the University of Chicago answered, writing, names in all caps is not conventional. It is not Chicago style to put anything in all caps. For instance, even if Gone with the Wild was placed in all capital letters, appears on the title page all in caps, we would properly render it Gone with the Wind, uppercase, lowercase, or proper case in a bibliography. The only reason we can think of to do so is if you are quoting some material where it is important to the narrator to preserve the casing of the letters. We are not sure in what context you would like your proper name to appear in all caps, but it is likely to be seen as a bit odd. Law is extremely precise. Every letter, capitalization, punctuation, mark, etc. in a legal document is utilized for a specific reason and has legal, i.e. deadly force, consequences. If, for instance, one attempts to file articles of incorporation in the office of the Secretary of State of a state, if the exact title of the corporation, down to every jot and title, is not exactly the same each and every time the corporation is referenced in the document to be filed, the Secretary of State will refuse to file the papers. This is because each time the name of the corporation is referenced, it must be set forth identically in order to express the same legal entity. The tiniest difference in the name of the corporation identifies an entirely different legal person. It is therefore an eminently valid and possibly crucial question as to why the governmental courts, and agencies purporting to exist in some undefined, unapproved manner within the jurisdiction of this state insist on always capitalizing every letter in a proper name. Mary Newton Bruder, Ph.D., also known as the Grammar Lady, who established the Grammar Hotline in the late 1980s for the Coalition of Adult Literacy, was asked the following question: why do federal and state government agencies and departments, judicial and administrative courts, insurance companies, etc., spell a person's proper name in all capital letters? For example, if my name is John Paul Jones, uppercase, lowercase, is it proper at any time to write my name as all capital letters, John Paul Jones? Dr. Bruder's reply was short and to the point. It must be some kind of internal style. There is no grammar rule about it. It seemed that these particular grammatical experts had no idea why proper names were written in all caps. So we began to assemble an extensive collection of reference books authored by various publishers, governments, and legal authorities to find the answer. What English grammar reference books say: Manual on Usage and Styles. One of the reference books obtained was the Manual on Usage and Styles, 8th edition, ISBN 1878-674-51X, published by the Texas Law Review in 1995. Section D, capitalization, paragraph D, 1:1 states, always capitalize proper nouns. Proper nouns, independent of the context in which they are used, refer to specific persons, places, or things. Ergo, Dan, Austin, Rolls-Royce. Paragraph D, 3:2, section D states, capitalize people, state, and any other terms used to refer to the government as a litigant, ergo the people's case, the state's argument. In that context, the people is capitalized and state is capitalized, but everything else that precedes it is lowercase. But do not capitalize other words used to refer to litigants, ergo plaintiff and defendant. Either no attorney, judge, or law clerk in Texas has ever read the recognized law style manual that purports to pertain to them, or the act is a deliberate violation of the rules for undisclosed reasons. In either ignorance of the law excuses no one, or violation, one violating the law he enforces on the others is acting under title of nobility and abrogating the principle of equality under the law, or other words, a miscarriage of justice or a blatant abortion of justice of the law. They continue to write plaintiff, defendant, state of Texas, and proper names of parties in all capital letters on every court document. The Elements of Style, another well-recognized reference book. This Elements of Style, 4th edition, ISBN 02053902X, written by William Strunk Jr. and E.B. White, published by Allen and Bacon in 1999. Within this renowned English grammar and style reference book is found only one reference to capitalization, located within the glossary at proper noun, page 94, where it states, the name of a particular person, Frank Senator, place Boston, or thing, Moby Dick, proper nouns are capitalized, and the preceding letters are lowercase. There's an obvious and legally evident difference between capitalizing the first letter of a proper name as compared to capitalizing every letter used to portray the name. The American Heritage Book of English Usage. The American Heritage Book of English Usage, a practical and authoritative guide to contemporary English, published in 1996 at Chapter 9, Email Conventions and Quirks. Informality states, to give a message special emphasis, an emailer may write entirely in capital letters, a device emailers refer to as screaming. Some of these visual conventions have merged as a way of getting around the constraints on data transmissions that now limit many networks. Here is a reference source with contemporary modern English that state, it is of an informal manner to write every word of specifically an electronic message, aka email, in all capital letters. They say it's screaming to do so. By standard definition, we presume that is the same as shouting or yelling. Are all judges as well as their court clerks and attorneys shouting at us when they corrupt our proper name in this manner? If so, what happened to the decorum of the court if everyone is yelling? Is the insurance company screaming at us for paying the increased premiums on our policy? This is doubtful. As to any standard generalization, even though specific individual instances may indicate this to be true, it is safe to conclude, however, that it would also be informal to write a proper name in the same way. Does this also imply that those in legal profession are writing our Christian names informally on a court documents? Are not attorneys and the courts supposed to be specific, formally writing all legal documents to the letter of the law? If the law is at once both precise and not precise, what is its significance, credibility, and force and effect? New Oxford Dictionary of English. The New Oxford Dictionary of English is published by the Oxford University Press. Besides being considered the foremost authority on the British English language, this dictionary is also designed to reflect the way language is used today. Through example sentences and phrases, we submit the following definitions from the 1998 edition. Proper noun, also proper name. Noun, a name used for an individual, person, place, or organization, spelled with an initial capital letter, ergo Jane, London, and Oxfam. Again, all upper lower case, proper case words. Name, noun, 1. A word or a set of words by which a person, animal, place, or thing is known, addressed, or referred to. My name is Parson, John Parson. Kalwasser is the German name for lime water. Verb 2, identify by name. Give the correct name for. The dead man has been named as John Macintosh. Phrase 3, in the name of bearing or using the name of a specified person or organization, a driving license in the name of William Saunders. Again, all the names are proper case, upper lower case. And this is from the Oxford Dictionary, and that flies about seen better days. I'll tell you that right now. The Newberry House Dictionary of the American English, published by Monroe Allen, Publisher Inc., 1999. Name: C, a word by which a person, place, or thing is known. Her name is Diana Daniels. Again, proper case, upper lower case. We can find absolutely no example in any recognized reference book that specifies or allows the use of an all capital letters name, proper or common. There is no doubt that a proper name, to be grammatically correct, must be written with only the first letter capitalized, with the remainder of the word in a name spelled with lowercase letters. U.S. Government Styles Manual is the spelling and usage of a proper name defined officially by U.S. government. Yes, the United States Government Printing Office, in their Style Manual, March 1984 edition, the most recent edition published as of March 2000, provides comprehensive grammar, style, and usage for all government publications, including court and legal writings. Chapter 3, Capitalization, at subsection 3.2, prescribes rules for proper names. Proper names are capitalized. Examples are given: Rome, Brussels, John Macadam family, Italy, Anglo-Saxon. At Chapter 17, Court Work, the rules of capitalization, as mentioned in Chapter 3, are further reiterated. 17.1, Court Work differs in style from other work only as it's set forth in this section. Otherwise, the style prescribed in the preceding section will be followed. After reading subsection 17 in its entirety, I found no other reference that would change the grammatical rules and styles specified in Chapter 3 pertaining to capitalization. At subsection 17.9, this same official U.S. government manual states, in the titles of cases, the first letter of all principal words are capitalized, but not such terms as defendant and appellee. This wholly agrees with the Texas Law Review Manual on usage and styles as referenced above. Examples shown in subsection 17.12 are also consistent with the aforementioned 17.9, specified, that is, all proper names are to be spelled with capital letters first, the balance of each spelled word with lowercase letters following. Grammar, punctuation, and capitalization. The National Aeronautics and Space Administration, otherwise identified as NASA, has published one of the most concise U.S. government resources on capitalization. NASA publication SP 7084, Grammar, Punctuations, and Capitalizations, a handbook for technical writers and editors, was compiled and written by the NASA Langley Research Center in Hampton, Virginia, at Chapter 4, Capitalization. They state in 4.1, Introduction, first we should define terms used when discussing capitalization. All caps means that every letter in an expression is capital, like this. And they're just simply showing like this is all capital letters. Caps and IC means that the principal word of an expression are capitalized like this. Again, upper, lowercase, and proper format. Caps and small caps refer to a particular font or of type containing small capital letters instead of lowercase letters. Elements in a document, such as headings, titles, and captions, may be capitalized in either sentence style or headline style. Sentence style calls for capitalization of the first letter and proper nouns, of course. Headline style calls for capitalization of all principal words, also called caps and IC. Modern publishers tend toward a down style of capitalization, that is, toward use of fewer capitals rather than an up style. Here we see that in headline, titles, captions, and in sentences, there is no authorized usage of all caps. At 4.4.1, capitalization with acronyms, we find the first authoritative use for all caps. Acronyms are also formed with capital letters. Acronyms are often coined for a particular program or study and, therefore, require definition. The letters of an acronym are not capitalized in the definition unless the acronym stands for a proper name. The best electronic publish system combined what you see is what you get. WYSIWYG is actually incorrect. But the correct way of doing it is the best electronic publishing system combined what you see is what you get is WYSIWYG. And that would be proper. But Langley is involved with the National Aerospace Plane NASP program. This cites, for example, you little bastard, you're going to die today. I can just tell it. This cite, by example, that using all caps is allowable in an acronym. Acronyms are words formed from the initial letters of successive parts of a term. They never contain periods and are often not standard, so the definition is required. Could this apply to lawful proper Christian names? If that were true, then John Smith, all capital letters, would have to follow a definition of some sort, which it does not. For example, only if John Smith were defined as John Orley Holistic Nutrition of the Smith Medical Institute to Holistics, John Smith would this apply. The most significant section appears at 4.5, Administrative Names. Official designation of political division and of other organized bodies are capitalized. Names of political divisions: Canada, New York State, United States Northwest Territories, Virgin Islands, or Ontario Province. Names of governmental units: U.S. Governmental Executive Department, U.S. Congress, U.S. Army, U.S. Navy. They're all capitalized. Like the U.S. is obviously both letters are capitalized, and everything else is uppercase, lowercase, in proper format. According to this official U.S. government publication, the states are never to be spelled in all caps, such as New York State or State of Nebraska, or however they're doing it this day and age, which you're all finding that if you go and look at the documentation, it's in all capital letters, and it's never to be spelled like that. It's a violation of the rules of grammar, the law of grammar. The proper English grammar and legal style is New York State, uppercase, lowercase. This agrees once again with Texas Law Review. Review manual on usage and style. The use of a legal fiction, the Real Life Dictionary of the Law. The author of the Real Life Dictionary of the Law, Gerald and Kathleen Hill, are accomplished. Excuse me for a second. Are accomplished scholars and writers. Gerald Hill is an experienced attorney judge and law instructor. Here is how the term legal fiction is described. Legal fiction, noun, a presumption of fact assumed by a court for convenience, consistency, or to achieve justice. There is an old adage, fiction arises from the law and not law from fiction. Orrin's Dictionary of Law. From Orrin's Dictionary of Law, published by the West Group, 1999, within the definitions of fiction is found. A legal fiction is an assumption that something that is or may be false or non-existent is true or real. Legal fictions are assumed or invented to help do justice. For example, bringing a lawsuit to throw a non-existent John Doe, which is uppercase, lowercase, off your property used to be the only way to establish a clear right to the property when legal title was uncertain. Merriam-Webster's Dictionary of Law. Merriam-Webster's Dictionary of Law, 1996, states, legal fiction, something assumed in law to be fact irrespective of the truth or accuracy of that assumption. Example, the legal fiction that a day has no fractions. Fields versus Fairbanks, North Star Borough, 818, P2D 658, 1991. This is the reason behind the use of the all caps when writing a proper name. The U.S. and state governments are deliberately using a legal fiction to address the lawful, real, flesh and blood man or woman. We say this is deliberate because their own official publications state that proper names are not to be written in all caps. They are deliberately not following their own recognized authorities. In the same respect, by identifying their own government entities in all caps, they are legally stating that it is also intended to be a legal fiction, as stated by Dr. Mary Newton Brunder in the beginning of this memorandum. The use of the all caps for writing a proper name is an internal style for what it apparently a predetermined usage and, at this point, unknown jurisdiction. The main key to legal fiction is assumption, as noted in each definition above. Conclusion: there are no official or unofficial English grammar styles manuals or reference publications that recognize the use of all caps when writing a proper name. To do so is by fiat, within and out of an undisclosed jurisdiction, by unknown people, for unrevealed reasons, by juristic license of arbitrary presumption not based on fact. The authors of the process unilaterally create legal fictions for their own reasons and set about to get us to take the bait, fall for the deceit. Assumption of a legal fiction. An important issue concerning this entire matter is whether or not a proper name, perverted into an all caps assemblage of letters, can be substituted for a lawful Christian name or any proper name, such as State of Florida. Is the assertion of all capital letters name legal? If so, from where does this practice originate and what enforces it? Well, there's a doctrine called the doctrine of idiom sonum. All right, and for those of you that don't understand what the doctrine of idiom sonum is, if it looks the same and it sounds the same, there's a presumption that it is the same. All right? And you have to defeat that presumption. You have to overcome it. So how do we overcome it? What is one of the best ways that you can overcome something like that? Well, dissimilar things should not be joined, and similar is not same. And if you can remember those two maxims, you might be able to save your ass in a legal setting when you're trying to distinguish between the two. And this fly has seen better days. Got your ass. Alright, I warned him. I give fair notice. That was due process of law. He didn't fucking listen. He's dead now. Lord save his soul. Assumption of legal fictions. An important issue concerning this entire matter is whether or not proper names perverted into the all caps assemblage of letters can be submitted for a lawful Christian name or any proper name, such as a State of Florida. Is the assertion of all capital letters names legal? If so, where does this practice originate and what enforces it? A legal fiction may be employed when the name of the person is not known and therefore using the fictitious name John Doe as a tentative or interim artifice to surmount the absence of the true knowledge until the true name is known. Upon discovering the identity of the fictitious name, the true name replaces it. In all cases, a legal fiction is an assumption of purported fact without having shown the fact to be true or valid. It is an acceptance with no proof, which would be prima facie evidence. It stands true in fact and law until somebody else proves the contrary, right? Or simply rebuts and rebukes it. Simply to assume is to pretend. Warren's Dictionary of Law says that the word assume means to take up or take responsibility for, to receive, to undertake, see assumption, to pretend, to accept without proof. These same basic definitions are used by nearly all of the modern law dictionaries. It should be noted that there is a difference between the meaning of the second and third definition with that of the first. Pretending and accepting without proof are of the same understanding and meaning. However, to take responsibility for and receive, or assumption, does not have the same meaning. Orens defines assumption as formally transforming someone else's debt into your own debt. Compare with guarantee. The assumption of a mortgage usually involves taking over the seller's mortgage debt when buying a property, often a house. Now, what happens if all the meanings for the words assume are combined in a literal and definitive sense? The meaning of assume would be the pretend acceptance without proof that someone has taken responsibility for, has guaranteed, or has received a debt. Therefore, if we apply all this in defining a legal fiction, the use of a legal fiction is an assumption or pretension that the legal fiction named has received and is responsible for a debt of some sort. Use of a legal fiction, John P. Jones, all capital letters, in place of the proper name, John Paul Jones, uppercase, lowercase, proper case, implies an assumed debt guarantee without any offer of proof. The danger behind this is that such an unproven assumption is made. Unless the assumption is proven wrong, it is considered valid. An assumed debt is valid unless proven otherwise. An unrebutted affidavit, claim, or charge stands as the truth in commerce. This is in accord with the Uniform Commercial Code, valid in every state, and made a part of the statutes of each state. A name written in all caps resembling a proper name, but grammatically not a proper name, is being held as a debtor for an assumed debt. Did the parties to the complaint incur that debt? If so, how and when? Where is the contract of indebtedness that was signed and the proof of the default thereon? What happens if the proper name, i.e. John Paul Jones, uppercase, lowercase, answers for or assumes the fabricated name, i.e. John P. Jones, all capitalized? The two become one and the same. This is the crux for the use of the all caps name by the U.S. government and the states. It is the way that they can bring someone into the de facto venue and jurisdiction that they have created. By implication of definition, this also is for the purpose of some manner of assumed debt. Why won't they use the state of Texas, uppercase, lowercase, or John Doe, uppercase, lowercase, in proper format in their courts or on the driver's license? What stops them from doing this? Obviously, there's a reason for using the all caps name, since they are very capable of writing proper names, just as their own official styles manual states. The reason behind legal fictions is found within the definition as cited above. The legalities of all capital letter names. We could go on for hundreds of pages citing the legal basis behind the creation and use of the all capital letters names. In a nutshell, fabricated legal persons, such as the state of Texas, all capital letters, can be used to fabricate additional legal persons. Fictions arise from the law, not the law from the fictions. Bastard legal person originated from any judicial governmental actors that wish to create them, regardless of whether he, she, it is empowered by law to do so. However, a law can never originate from a fictional foundation that doesn't exist. The generic and original U.S. Constitution was validated by treaty between individual nation states, all of which are artificial corporate entities since they exist in abstract idea and construct. Contained within it is the required due process of law for all the participating nation states of that treaty. Representatives of the people in each nation state agreed upon and signed it. The federal government is not only created by it, but is also bound to operate within it the guidelines of constitutional due process. Any purported law that does not originate from constitutional due process is a fictional law without validity. Thus, the true test of any American law is its basis of due process according to the organic U.S. Constitution. Was it created according to lawful process or created outside of lawful process? Executive orders and directives. For years, many have researched the lawful basis for creating all caps juristic persons and have concluded that there is no such foundation according to valid laws and due process. But what about those purported laws that are not valid and have not originated from constitutional due process? There's a very simple answer to the creation of such constitutional due process, of such purported laws that are really not laws at all. Executive orders and directives, they are color of law. Without being valid laws of due process, these executive orders and directives have the appearance of law and look as if they are law, but according to due process, they are not laws. Rather, they are laws based on fictional beginnings and are the inherently defective basis for additional fictional laws and other legal fictions. They are regulated and promulgated by administrative code, rules, and procedures, not due process. Currently, executive orders are enforced through the charade known as the Federal Administrative Procedures Act. Each state has also adopted the same fatally flawed administrative laws. President Lincoln established executive orders. 85 years after the independence of the United States, 7 southern states of America walked out of the second session of the 36th Congress on March 27, 1861. In so doing, the constitutional due process quorum necessary for Congress to vote was lost and Congress was adjourned, sine die, without a day to reconvene. This meant that there was no lawful quorum to set a specific day and time to reconvene, which, according to Robert's Rules of Order, dissolved Congress. This dissolution automatically took place because there are no provisions within the Constitution allowing the passage of any congressional vote without a quorum of the state. So, March 27th, 1861, since that day, there has been no Congress, ladies and gentlemen. There has been no new laws created in the de jure America. None. Everything has been done in the de facto. March 27th, 1861. Lincoln's second executive order, and the reason he was able to do the executive orders is because, well, now Lincoln is the commander-in-chief of the military, period. Lincoln's second executive order of April 1861 called Congress back into session days later, but not under the lawful authority or lawful due process of the Congress, solely in his capacity as commander-in-chief of the U.S. military. Lincoln called Congress into session under authority of martial law. Since April of 1861, Congress has not met based on lawful due process. The current Congress is a legal fiction based on nothing more meritorious than yeah. So what are you going to do about it? Having a monopoly on the currency, law, and what passes for government, and most of the world's firepower, the motto of the powers that be is, we've got what it takes to take what you've got. Legal fictions, laws, such as the Reconstruction Acts and the implementation of the Lieber Code, were instituted by Lincoln soon thereafter and became the basis for the current laws in the U.S. Every purported act in effect today is de facto, based on colorable fictitious entities created arbitrarily out of nothing without verification, lawful foundation, or lawful due process. All such laws are not law, but rules of rulership by forced conquest originating from and existing in military martial law jurisdiction. Military martial law jurisdiction. Jurisdiction of war, win-lose interactions consisting of eating or being eaten, living or dying, food chain, law of necessity, suspension of all law other than complete freedom to act in any manner, to eat, kill, or destroy, or avoid being eaten, killed, or destroyed. No law equals also lawlessness. Complete absence of lawful basis to create any valid law. Contractually, being a victim of those acting on the alleged authority granted by the law of necessity equals no object, no lawful object, valuable consideration, free consent of all involved parties, absence of fraud, duress, malice, and undue influence. No bona fide enforceable contract, no valid enforceable nexus, absolute right to engage in any action of any kind in self-defense, complete and total right to disregard any alleged jurisdiction and demand from self-admitted outlaws committing naked criminal aggression without any credibility, and right to demand allegiance and compliance from anyone. Yeah, that last one, what a doozy. Every president of the United States since Lincoln has functioned by executive orders issued from a military martial law jurisdiction, with the only law being the law of necessity, i.e. the war powers. The war powers are nothing new. Indeed, they have been operational from the instant the first man thought he would hide from God, tried to cheat ethical and natural law by overreaching, invade the space and territory of others, covet other people's land or property, steal the fruits of their labors, and attempt to succeed in life by win-lose games. All existing authority in the United States today derives exclusively from the war powers. Truman's reaffirmation of operational authority under the war powers begins now. Therefore, I, Harry S. Truman, President of the United States of America, acting under the and by virtue of the authority vested in me by Section 5B of the Trading with the Enemy Act of October 6, 1917, 40 Stat 415, as amended, Section 5B of Appendix to Title 50, which is the Military Code, Title 50, and Section 4 of the Act of March 9, 1933, 48 Stat 2, Sick Transit Rights, Substance, Truth, Justice, Peace, and freedom in America, the land of the free and the home of the brave. And it's really the land of the slave, but we'll leave it at that for a second. People are starting to wake up. Maybe they'll get a set of testicles. We'll see. The abolition of the English and American common law. Here's an interesting quote from the 1973 session of the U.S. Supreme Court. The American law in this country, the law in effect in all but a few states until mid-19th century, has the pre-existing English common law. It was not until after the war between the states that legislation began generally to replace the common law. Roe v. Wade, 410 U.S. 113. In effect, Lincoln's second executive order abolished the recognized English common law in America and replaced it with laws based on a fictional legal foundation, i.e., executive orders and directives executed under authority of the war powers. Most states still have a reference to the common laws within their present-day statutes. For example, in the Florida Statutes, 1999, Title I, Chapter 2, at subsection 2.01, common law and certain statutes declared in force, it states, the common law and statute laws of England, which are of the general and not a local nature, with the exception hereinafter mentioned, down to the 4th day of July, 1776, are declared to be of force in this state, provided that said statutes and common law be not inconsistent with the Constitution and laws of the United States and the acts of the legislature of this state. History, I'm not going to read all those numbers. That was in November of 6 of 1829. Note that the basis of the common law is an approved act of the people of Florida by resolution on November 6, 1829, prior to Lincoln's Civil War. Also note that the subsequent laws, as a result of acts of the Florida legislature and the United States, now take priority over the common law in Florida. In April 1861, the American and English common law was abolished and replaced with legal fiction laws, aka statutes, rules, and codes based on executive orders and not due process specified within the organic Constitution, existing and functioning under the laws of necessity ab initio from the beginning. They are all non-law and cannot validly assert jurisdiction, authority, or demand for compliance from anyone. They are entirely rules of rulership, i.e., organized piracy, privilege, plunder, and enslavement, intended to and enforced by those who would rule over others by legalized violence in a complete absence of moral authority, adequate knowledge, and natural law mechanics to accomplish any result other than disruption, conflict, damage, and devastation. The established maxims of law apply. One who exercises jurisdiction out of his territory cannot be obeyed with impunity. Applying it all to current laws, an established maximum of law states the importance of the name. In order rightly to comprehend a thing, inquire first into the names, for a right knowledge of things depends upon their names. Colorado Little 68. Title 3, Pleadings and Motions, Rule 9A, Capacity, Federal Rule of Civil Procedure states in pertinent part, when an issue is raised as to the legal existence of the named party or the party's capacity to be sued or the authority of a party to be sued, the party desiring to raise the issue shall do so by specific negative averment, which shall include supporting particulars. At this juncture, it is clear that the existence of a name written with all caps is a necessity-created legal fiction. This is surely an issue to be raised, and the supporting particulars are outlined within this memorandum. Use of the proper name must be insisted upon as a matter of abatement, correction, for all parties of an action of purported law. However, the current courts cannot correct this since they are all based on presumed assumed fictional law and must use artificial juristic names. Instead, they expect the lawful Christian man or woman to accept the all caps name and agree by his silence to be treated as if he or she were a fictional entity invented and governed by the mortal enemies. They must go to unlimited lengths to deceive and coerce this compliance, or the underlying criminal farce would be exposed, and a worldwide plunder enslavement racket that has held all of life on this planet in a vice grip for millennia would crumble and liberate every living thing. At this point, the would-be rulers of the world would be required to succeed in life by honesty, productive labors, the way those upon whom they parasitically feed are forced to conduct their lives. So in other words, lawyers and bar rats would be faced to actually have some calluses on their hands and not from just beating off. They'd actually have to go do something like dig holes and build shit and do something productive instead of fleece the American people based upon their yeah, I don't even want to get into that. This memorandum covers it all. Oklahoma statutes, since the entire game functions on the basis of people's failure to properly rebut a rebuttable presumption, that the issue then becomes how to properly rebut their presumptions that you are knowingly, intentionally, and voluntarily agree to be treated as if you were the all caps name. One angle of approach is found in the requirement for proper names to be identified in any legal dispute. This includes a mandate to correct the legal paperwork involved when proper names are provided. In regard to criminal prosecution, this is clearly set forth in the Oklahoma statute, chapter 22, subsection 403. When a defendant is indicted or prosecuted by a fictitious or erroneous name, and in any stage of the proceeding his true name is discovered, it must be inserted in the subsequent proceedings, referring to the fact of his being charged by the name mentioned in the indictment or information. American jurisprudence. In general, it is essential to identify parties to court actions properly. If the alleged parties to an action are not precisely identified, then who is involved with whom or what and how. If not properly identified, all corresponding judgments are void in ab initio from the beginning, non pro tunc, as outlined in Volume 46, American Jurisprudence 2D at Judgments, subsection 100, Parties. A judgment should identify the parties for and against whom it is rendered, with such certainty that it may be readily enforced, and a judgment which does not do so may be regarded as void for uncertainty. Such identification may be achieved by naming the person for and against whom the judgment is rendered. Technical deficiencies in the naming of the person for and against whom judgment is rendered can be corrected if the parties are not prejudiced. A reference in a judgment to a party plainly liable, followed by an omission of the party's name from the language of the decree, at least gives rise to an ambiguity and calling for an inquiry into the court's real intention as reflected in the entire record and surrounding circumstances. Footnote numbers and cites are omitted. The present situation in America, a legal person, a legal fiction, one of the terms used predominantly by the present civil government and courts in America is legal person. Just what is a legal person? Some definitions are: a legal person, a body of persons or an entity, as a corporation considered as having many of the rights and responsibilities of a natural person and especially the capacity to sue and be sued. Merriam-Webster's Dictionary of Law, 1996. Person: 1. A human being, a natural person. 2. A corporation, an artificial person. Corporations are treated as persons in many legal situations. Also, the word person includes corporation in most definitions in this dictionary. 3. Any other beings entitled to sue as a legal entity, a government, an association, a group of trustees, etc. The plural of person is persons, not people. See that word. Oren's Dictionary of Law, West Group, 1999. Person, an entity with legal right and existence, including the ability to sue and be sued, to sign contracts, to receive gifts, to appear in court, either by themselves or by a lawyer, and generally other powers incidental to the full expression of the entity in law. Individuals are persons in law unless they are meres or under some kind of other incapacity, such as a court finding of mental incapacity. Many laws give certain powers to persons which, in almost all instances, include business organizations that have been formally registered, such as partnerships, corporations, or associations. Durkheim's Law Dictionary. Person, noun, persons, Latin persons, said to be compounded of, per, through, or by, and sonus, sound, a Latin word signifying primarily a mask used by actors on the stage. Webster's 1828 Dictionary. A corporation incorporated under de jure law, i.e. by bona fide express contract between real beings capable of contracting, is a legal fact. Using the juristic artifice of presumption or assumption, a device known as a legal fiction, implied contract, constructive trust, another entirely separate entity, can be created by using the name of the bona fide corporate legal fact, the name of the corporation, by altering the name of the corporation into some other corrupted format, such as all capital letters, or corporation into some other corporate format, such as all capital letters or abbreviated words in the name. The corporation exists in law, but has arbitrarily been assigned another name, all capital letters. No such corporation legal fact, nor any valid law, nor even a valid legal fiction can be created under the law of necessity, i.e. under no law. Likewise, the arbitrary use of the legal fiction artifice of right of presumption over unwary, uninformed, and usually blindly trusting people can be legitimately exercised under no law. Anything whatsoever done under alleged authority of naked criminal aggression, i.e. law of necessity, can be rendered legitimate. Maxim of law describing necessity includes: necessity has no law. PLOWD 18 and 15 VIN ABR 534 22 ID 540. In time of war, laws are silent. Non-existent law, the legal condition that universally prevails in the official system of the world today, means that no lawful basis exists upon which anything can be created or be made to transpire, upon which basis allegiance and obedience can be legitimately demanded. Acting under the law of necessity, i.e. lawlessness, also complete and total right of everyone to disregard any and all alleged assertion of any lawful, verifiable, and legitimate jurisdiction over anything or anyone. Anyone acting against anyone under such non-law is self-confessing to be a naked criminal aggressor and con man, who has forfeited all credibility and right to demand allegiance, obedience, and or compliance with any jurisdiction he might assert. If you, as a real being, are in a real law and it is impossible for an attorney or judge to recognize or access it, you are not and cannot be made subject to by them in their jurisdiction. The crucial issue is then how to notice them of your position and standing. A person created under the de jure law with the person's identifying name appearing as prescribed by law and according to the rule of English grammar is a legal fact. A corrupted, altered ego version of that name manufactured under the legal fiction of right of presumption will have credibility only so long as the presumption remains unchallenged. The rule of the world is that anything and everything skates unless you bust it. Legal or lawful. It is crucial to define the difference between legal and lawful. The generic Constitution references genuine law. The present civil authorities and their courts use the word legal. Is there a difference in the meaning? The following is quoted from a dictionary of law in 1893. Lawful, in accordance with the law of the land, according to the law, permitted, sanctioned, or justified by law. Lawful properly implies a thing comfortable to or enjoyed by law. Legal, a thing in the form or after the manner of law, or binding by law, a writ or warrant issuing from any court under color of law, is a legal process, however defective. See legal, bold emphasis added. Legal, Latin, legalis, pertaining to the understanding, the exposition, the administration, the science, and the practices of law, as the legal profession, legal advice, legal blank, newspapers, implied or imputed in law, opposed to actual legal looks, more to the letter from appearance, and lawful to the spirit, substance, and content of the law. Legal is more appropriate for conformity to positive rules of law, lawful for accord with ethical principles. Legal imports rather that the form's appearance of the law are observed, that the proceeding is correct in method, that rules prescribed have been obeyed. Lawful, that the right is act full in substance, that moral quality is secured. Legal is the antithesis of equitable and equivalent of constructive. To Abbott's Law Dictionary 24, bold emphasis added. Legal matters, administrative, conform to and follow rules. They are equitable in nature and are implied, presumed, rather than actual express. A legal process can be defective in law. This accords with the previous discussion of legal fiction and color of law. To be legal, the matter does not have to follow the law. Instead, it conforms to the and follows the rules or forms of law. This is why federal and state rules of civil and criminal procedures are cited in every court petition so as to conform to legal requirements of the specific juristic persons named, ergo, State of Georgia, all capital letters, or U.S. federal government, all capital letters, that rule the courts. Lawful matters are ethically enjoyed in the law of the land, the law of the people, and are actual in nature, not implied. This is why whatever true law was upheld by the organic constitution has bearing or authority in the present day legal court. It is impossible for anyone in authority today to access or even take cognizance of true law, since authority is the law of necessity. Title 12 USC 95. Therefore, it would appear that the meaning of the word legal is color of law, a term which Black's Law Dictionary 5th edition defines as color of law, the appearance or semblance without the substance of legal right, misuse of power, possessed by virtue of state law, and made possible only because wrongdoer is clothed with authority of the state. Is action taken under color of law. Black's Law Dictionary, 5th edition, page 241. Executive order, rule the land. The current situation is that legalism has usurped and engulfed the law. The administration of legal rules, codes, and statutes now prevail instead of actual law. This takes place on the federal as well as the state level. Government administrates what it has created through its own purported laws, which are not lawful but merely legal. They are arbitrary constructs existing only because of the action of people acting on fictitious self-created authority, i.e. no authority at all. They are authorized and enforced by legal executive orders. Executive orders are not lawful and never have been. As you read the following, be aware of the words code and administration. Looking at the United States Census 2000 reveals that legal authority for this census comes from the Office of Management and Budget, OMB, approval number 0607-0856. The OMB is part of the Executive Office of the President of the United States. The U.S. Census Bureau is responsible for implementing the National Census, which is a division of the Economic and Statistic Administration of the U.S. Department of Commerce, USDOC. The USDOC is a department of the executive branch. Obviously, Census 2000 is authorized, carried out, controlled, enforced, and implemented by the President. The executive branch of the federal government functions as it has been since 1861 in the lawless realm of necessity, which is now even more degenerate than when it commenced under Lincoln. In fact, the executive office of the president controls the entire nation through various departments and agencies affecting justice, communications, health, energy, transportation, education, defense, treasury, labor, agriculture, mails, and much more. Through a myriad of executive orders, proclamations, policies, and decisions. Every U.S. president since Lincoln has claimed his authority for the executive order on Article 2, Section 2 of the U.S. Constitution. The president shall be commander-in-chief of the Army and the Navy of the United States and of the militia of the several states when called into actual service of the United States. He shall have power and by and with the advice and the consent of the Senate to make treaties, provided two-thirds of the senators present concur, and he shall nominate and by and with the advice and consent of the Senate shall appoint ambassadors, other public ministers and councils, judges of the Supreme Court, and all other officers of the United States whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officer as they think proper in the president alone, in the courts of law, or in the heads of department. I didn't want to add a word there. In reality, the Congress is completely bypassed since the Senate was convened in April 1861 by Presidential Executive Order Number 2, not by lawful constitutional due process. There is no United States Congress. The current Senate and House are like everything color of Senate, under the direct authority of the executive office of the president. The president legally needs neither the consent nor a vote from the Senate, simply because the Senate legal authority to meet exists only by executive order. Ambassadors, public ministers, councils, federal judges, and all officers of the United States are appointed by and under the authority of the executive office of the president, which means your fucking vote doesn't count. It don't fucking matter, people. We're under military occupation, which is martial law, because the proclamation of war was never lifted by Lincoln. And thus, every president, every year, reaffirms a national emergency, affirming his direct authority over the corporation, Title 28, 3002, 15A, because it's not a fucking legitimate government. Anyway, I'm going to keep saying this shit till I'm blue in the face or they shut me up, which I think that's coming, by the way. The Federal Registry is an executive function. The first official act of every incoming president is to reaffirm the war powers. He must do so, or he is devoid of powers to function in office. The war powers are set forth in the Trading with the Enemy Act of October 6, 1917. The Amendatory Act of March 9, 1933, the Banking Relief Act. In amendatory act, every citizen of the United States was made an enemy of the government, i.e. the Federal Reserve, IMF, et al., creditors in bankruptcy who have conquered the country by their great paper money banking swindle. For the past 65 years, the President's executive orders has become purported law simply by its publication in the Federal Register, which is operated by the Office of the Federal Register, OFR. In 1935, the OFR was established by the Federal Register Act. The purported authority for the OFR is found within the United States Code under Title 44 at Chapter 15. Subsection 1506, Administrative Committee of the Federal Reserve... I'm going to slow down here. Subsection 1506, Administrative Committees of the Federal Register, Establishment, and Composition Powers and Duties. The Administrative Committee of the Federal Register shall consist of the Archivist of the United States or Acting Archivist, who shall be chairman and officer of the Department of Justice designated by the Attorney General and the public printer or acting public printer. The director of the Federal Register shall act as secretary of the committee. The committee shall prescribe, with the approval of the president, regulation for carrying out this chapter. Notice that the entire administrative committee of the Federal Register is comprised of officers of the federal government. Who appoints all federal officers? The president does. This act also gives the president the authority to decree all the regulations to carry out the act. By this monopoly, the executive establishes, controls, regulates, and enforces the federal government without need for any approval from the Senate or anyone else other than his undisclosed superiors. Well, in this case, it'd probably be China. Did you notice the handlers of the president? The little Chinaman flying his little communist flag, standing behind old Slick Joe that managed to get so many votes. I look like Joe Biden right now. I'm so fucking confused. How in the fuck did that guy pull that off? I don't know. I'm confused. He operates with any accountability to the people at all. How can this be considered lawful? In 1917, President Woodrow Wilson couldn't persuade Congress to agree with his desire to arm United States vessels traversing hostile German waters before the United States entered World War I. So Wilson simply invoked the policy through a presidential executive order. President Franklin D. Roosevelt issued an executive order number 9066 in December 1941, forcing 100,000 Americans of Japanese descent to be rounded up and placed into concentration camps while all their property was confiscated. Is it a wonder that the Congress, which the president legally controls, did not impeach President Wilson Jefferson Clinton when the evidence for impeachment was overwhelming? On that note, why is it that attorney presidents have used executive orders the most? Who but an attorney would know and understand legal rules the best? Sadly, they enforce what's legal and ignore what's lawful. In fact, they have no access to what is lawful, since the entirety of their authority, which is ethically and existently suspicious, derives from the war powers. How debt is assumed by legal fictions. We now refer back to the matter of assumption, as already discussed, with its relationship to arbitrarily created juristic persons, ergo, State of California, all capital letters, or John P. Jones, all capital letters. Since an assumption by definition implies debt, what debt does a legal fiction assume? Now that we have explored the legal executive basis of the current federal and state governments, it's time to put all this together. The government use of all caps in place of proper names is absolutely no mistake. It signifies an internal legal rule and authority. Its foundation is pure artifice, and the results have compounded into more deceit in the form of created, promulgated, instituted, administered, and enforced rules, codes, statutes, and policies, i.e. the laws that appear to be, but are not, never were, and never can be. Quasi senti comdum sentai, it's all in Latin. Hold on a second. He who enjoys the benefit ought also to bear the burden. He who enjoys the advantage of a right takes the accompanying disadvantage, a privilege is subject to its condition or conditions. Bouvier's Maxims of Law, 1856. The birth certificate. Since the early 1960s, state governments themselves specially created juristic corporate persons signified by all caps have issued birth certificates to persons with legal fiction all cap names. This is not a lawful record of your physical birth, but rather the birth of the juristic all caps name. It may appear to be your true name, but since no proper name is ever written in all caps, either lawfully or grammatically, it does not identify who you are. The birth certificate is a government self-created document of title for its new property, i.e. the deed to the juristic name, artificial person, whose all caps name mirrors your true name. The birth certificate brings the new all caps name into colorable admiralty maritime law, the same way a ship and a ship of state is birth. One important area to address before going any further is the governmental use of older data storage from the late 1950s until the early 1980s. As a leftover from various teletype-oriented systems, many government data storage methods used all caps for proper names. The IRS was supposedly still complaining about some of their antiquated storage systems as recent as the 1980s. At first, this may have been a necessity of the technology at the time, not a deliberate act. Perhaps when this technology was first being used and implemented into the mainstream of communication, some legal experts saw it was a perfect tool for their perfidious intentions. What better excuse could there be? However, since local, state, and federal offices primarily used typewriters during that same time period, the birth certificate and other important documents, such as driver's license, were produced with typewriters. It's very doubtful that this purpose much of an excuse to explain all caps usage for proper names. The only reasonable usage of the older data bank all caps storage system would have been for addressing envelopes or certain forms in bulk, including payment checks, which the governments did frequently. Automated computer systems with daisy wheel and pin printers used prevalently in the early 1980s emulated the IBM electronic typewriter Courier or Helvetica font in both upper and lowercase letters. Shortly after, the introduction of lasers and inkjet printers with multiple fonts became the standard for the past 15 years. There is no excuse that the government computers will not accommodate the use of all lowercase letters unless the older data is still stored in its original form, i.e. all caps, and has not been translated due to the cost of the re-entry. But this does not excuse the entry of new data or legacy data. In fact, on many government forms today, proper names are in all caps, while other areas of the same computer-produced documents are in both upper and lowercase. One can only conclude that now, more than ever, the use of all caps in substitution, the writing a proper name, is no mistake. When a child is born, the hospital sends the original, not a copy, of the record of live birth to the State Bureau of Vital Statistics, sometimes called the Department of Health and Rehabilitative Services, HRS. Each state is required to supply that United States with birth, death, and health statistics. The state agency that receives the original record of live birth keeps it and then issues a birth certificate in the corrupted all caps version of the baby's true name, i.e. James Wilbur Smith. Certificate, noun, Middle English certificate, from Middle French, from medieval Latin suffixum, from late Latin, past participle, and certificare. To certify, 15th century, a document evidencing ownership or debt, Merriam-Webster's Dictionary, 1998. The birth certificate issued by the state is then registered with the U.S. Department of Commerce, the Executive Office, specifically through their own sub-agency, the U.S. Census Bureau, which is responsible to register vital statistics from all the states. The word registered, as it is used within commercial or legal-based equity law, does not mean that the all-caps name was merely noted in a book for reference purposes. When a birth certificate is registered with the U.S. Department of Commerce, it means that the all-caps legal person name thereon has become a surety or a grantor, a condition and obligation that is automatically and underwriting assumed, unless you rebut the presumption by effectively noticing them. It ain't me, baby. Registered security bond, Merriam-Webster's Dictionary of Law, 1996. Security, A, something as a mortgage or collateral that is provided to make certain the fulfillment of an obligation. Example, used his property as security for a loan. B, surety. 2, evidence of indebtedness, ownership, or the right of ownership. Bond. A usually formal written agreement by which a person undertakes to perform a certain act as fulfill the obligation of a contract with the conditions that failure to perform or abstain will obligate the person to pay a sum of money or will result in the forfeiture of money put up by the person or surety. One who acts as surety, an interest-bearing document giving evidence of a debt issued by a government body or a corporation that is sometimes secured by a lien on property, is often designed to take care of a particular financial need. Surety, the person who has pledged him or herself to pay back money or perform a certain action in the principal to a contract, fails as collateral and as part of the original contract. Duheim's Law Dictionary. 1. A formal engagement as pledged, given for the fulfillment of an undertaking. And 2. One who promises to answer for the debt or default of another. Under the Uniform Commercial Code, however, a surety includes a grantor, and the two terms are generally interchangeable. Merriam-Webster's Dictionary of Law, 1996, grantor, a person who pledges collateral for the contract of another, but separately as a part of an independently contract with the obligee of the original contract. Duheim's Law Dictionary. It is not difficult to see that the state created birth certificate with an all-caps name is a document evidencing a debt the moment that it is issued. Once a state has registered a birth certificate document with the U.S. Department of Commerce, the department notifies the Treasury Department, which takes out a loan from the Federal Reserve. The Treasury uses the loan to purchase a bond. The Feds holds a purchase money security interest in the bond from the Department of Commerce, which invests the sales proceeds in the stocks or bonds market. The Treasury Department then issues Treasury securities in the form of a Treasury bond notes or bills, using the bonds as surety for the new securities. This cycle is based on the future tax revenues of the legal person whose name appears on the birth certificate. This also means that the bankrupt corporate U.S. government can guarantee to the purchaser of their securities the lifetime labor and taxes revenues of every citizen of the United States American with a birth certificate as collateral for payment. This device is initiated simply by converting the lawful true name of the child into a legal juristic name of a person. Another maximum. The principal part of everything is in the beginning. Well begun is half done. Legally, you are considered to be a slave or indentured servant to various federal, state, and local governments via your state-issued and state-created birth certificate in the name of your all-caps person. Birth certificates are issued so that the issuer can claim exclusive title to the legal person created thereby. This is further compounded when the one voluntarily obtains a driver's license or a social security account number. The state even owns your personal and private life through your state-issued marriage license certificate issued in the all caps name. You have no rights in birth, marriage, or even death. The state holds title to all legal persons the state creates via birth certificates until the rightful owner, i.e. you, reclaims, redeems it by becoming the holder in due course of the instrument. The main problem is that the mother and father and then the 18-year-old man or woman voluntarily agree to this contrived system of plunder and slavery by remaining silent. A legal default latches and failing to claim one's own rights, the maximum of law becomes crucially operative. He who fails to assert his rights has none. The legal rules and codes enforce themselves. There is no court hearing to determine if those rules are correct. Government rules are self-regulating and self-supporting. Once set into motion, such laws automatically come into effect provided the legal process has been followed. The various bankruptcies. The legal person known as the United States is bankrupt and holds no lawful, constitutionally mandated silver or gold coin or bullion, with which to back any currency. All private held and federally held gold coin and bullion in America was seized via executive order April 5th, 1933, and paid to the creditor, the private Federal Reserve Corporation, under the terms of the bankruptcy. Congress still convening strictly under executive order authority, confirmed the bankruptcy through the joint resolution to suspend the gold standard and abrogate the gold clause, June 5th, 1933, House Joint Resolution 192, June 5th, 1933, 73rd Congress, First Session, Public Law 7310. This 1933 public law states, in part, every provision contained in or made with respect to any obligation which purports to give the obligee a right to require payment in gold or a particular kind of coin or currency or in any amount in money of the United States measured thereby is declared to be against public policy. The corporate U.S. declared bankruptcy as a second time, whereby the Secretary of Treasury was appointed receiver for the bankrupt U.S. in reorganization plan number Title 26, Title 5 U.S.C. 903, Public Law 94-564, and Legislative History, page 5,967. Since 1933, the only asset used by the United States to pay its debts to the Federal Reserve, to the Fed, have been the blood, sweat, and tears of every American unfortunate to be saddled with a birth certificate and a Social Security account. The U.S. government must conceal this fact from the American people at all costs. Their future labor and tax revenues have been legally pledged via the new all-caps juristic persons' names appearing on the birth certificate, i.e. the securities used as collateral for loans of credit out of thin fucking air, believe it or not, to pay daily operational costs, reorganization expenses in bankruptcy, insurance policies, premiums required to float the bankrupt government, and interest on the ever-increasing, wholly fraudulent debt. Y'all fucking slaves. It ain't about color. Get that racist bigot bullshit out your fucking head. This is some crazy cracker shit they're pulling on all of us, and you're all fucking slaves. It has nothing to do with melanin, has nothing to do with pigment, has everything to do with our fucking ignorance. We're all slaves. Get it right. And the only way that we can free ourselves is by ascending of the mind. And I'm telling you right now, I've been in some jurisdictions that would blow your guys' mind, where what should be done shall be done, where equity prevails, where everything is either black or it's white. There's no in between. It's either wrong or it's fucking right. There's no gray area. There's no gray area in the place that I venture to when I go into a courtroom, when I go into a courthouse. There is no gray area. It's either right or it's wrong. Period. All caps legal person versus lawful being. Just who or what is the all caps person, i.e. John Paul Jones or John P. Jones, the all capital letter name, or some other capital letter corruption thereof. It is the entity the government created to take the place of the real being, i.e. John Paul Jones, upper lowercase, the man, the lawful Christian name of the birthright, has been replaced with a legal corporate name of deceit and fraud. If the lawful Christian name answered as a legal person, the two are recognized as being one and the same. However, if the lawful being distinguishes himself, herself as party other than the legal fiction, the two are separated. As a result of the federal bankruptcy was the creation of the United States, which was made a part of the legal reorganization. The name of each state, which is all capital letters, was also converted to its respective all caps legal person, ergo state of Delaware, all capital letters. These new legal persons were then used to create more legal persons, such as corporations, with all capital letters names as well. Once this was accomplished, the con began to pick up speed. All areas of government and all alleged courts of law are de facto color of law and right institutions. The Circuit Court of Wayne County and the U.S. District Court, in all capital letters, can recognize and deal only with other legal persons, fictions. This is why a lawful name is never entered in their records. The all-cap legal person is used instead. Jurisdiction in such sham courts covers only other artificial persons. The proper jurisdiction for a lawful being is a constitutionally sanctioned common law venue court. Unfortunately, such jurisdiction was shelved in 1938. Remember how I keep telling you, they say if you bring us something, a court case after 1935, 1938, we'll honor it. That's because it's the law common to them administering the bankruptcy and you being a slave, and is no longer available. The only courts today are statutory commercial tribunals collecting tribute, plunder from their alleged creditors who think they have conquered the country on their way to ruling the world. Thanks for joining me. I hope this helps shed some light on where we're at today in history. It hasn't changed. It's not going to change, but I will tell you this. There is another realm that exists. There is another jurisdiction that is wholly untouched. It's so eloquent. It's so graceful. It's so beautiful. I struggle to put it in words, but it only happens to special people by special invitation. It's not something everybody will ever get an opportunity to be involved in or see. But hopefully, with you guys following me, you might get that opportunity. You might get a chance of walking through those gates. And if you do, I hope you take heed into the lessons and the things that I'm showing you, because it's going to take determination. It's going to take honor, dignity, respect, and not taking shit from anybody to get there. You're going to have to do your own research. You're going to have to ascend to your mind. I understand what the birth certificate is. It's a bailment receipt. It's a bailment certificate, all right? And I'm the bailor for the bailee. And who would be the bailee? The United States. I'm part owner of this shit show. And I haven't been getting my dividends and derivatives. I'm not too happy about it. All right? So anyway, talk to you guys soon.